Court is in session in two cases, calls number 330-372 and calls number 330-568. Case is style, the state of Texas versus Christopher J. Stabler. Mr. Stabler is not present. Mr. Stabler, it has been brought to the court's attention that Mr. Stabler has cut off his GPS monitor that he was required to have as a condition of his bond. And so the court is having an emergency hearing. Mr. Stabler is represented by Mr. Charles Rojas. Mr. Rojas his office was contacted by the court coordinator, Ms. Melanie Smith. She left a message on his cell phone, and he did not answer on the cell phone. So because this situation is such that requires the court's immediate attention, the court is having an emergency hearing regarding whether or not Mr. Stabler has violated the condition of his bond. Now, we have present in court Mr. James or Mr. Blake Ham, who is Assistant District Attorney for Jefferson County, Texas. And we have on Zoom Ms. Tara Ridenour, and Ms. Ridenour works for the bond company, Keith Day Bonding Company, and Ms. Ridenour office was contacted by the company that monitors the GPS system. And so at this time, first of all, we'll start off with Mr. Blake Ham. Now, Mr. Ham, you like to go forward on this particular matter?
Yes, Your Honor. The state would call Ms. Ridenour.
Okay, Ms. Ridenour, would you please raise your hand, right hand? Ms. Ridenour, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Ms. Ridenour, you may put your hand down. Mr. Ham, you may go forward.
Thank you, Your Honor. Ms. Ridenour, we haven't met before. My name is Blake Ham. I'm with the prosecutor's office here in Jefferson County, Texas.
Yes, sir.
Could you please explain who you work for and what it is you do? Briefly.
So I work for Keith Day at Professional Bail Bonding. I am his office manager here.
Thank you. And are you familiar with the defendant in these cases by the name of Christopher J. Stabler?
Yes, sir. He's been on bond with us for quite a while. So I am familiar with him, yes.
Okay. And you said the name of the bonding company is Professional Bail Bonding?
Yes, sir.
Is Professional Bail Bonding responsible for monitoring Mr. Stabler's behavior while he's out on bond?
Yes, sir. We do have some rules in place for anyone that's on bond to make sure that they're doing what they're supposed to be doing to be out.
And is Professional Bail Bonding aware that Mr. Stabler, as a condition of his bond in these cases, is required to wear a global positioning monitoring system device at his expense during the term of while he's on bond?
Yes, sir. When we posted his bond originally, we were told that he did have an ankle monitor that he would have to be required to wear in order to be out on bond.
Okay, and who provided the ankle monitor for Mr. Stabler?
That would be Mr. Johnny Pelt. They're the ones who he contracted with.
Okay, and so Mr. Pelt advised Professional Bail Bonding that Mr. Stabler was wearing an ankle monitor?
Yes, sir.
Okay, and has that changed?
As far as him wearing his monitor, yes, sir. We were notified at 11:02 p.m. last night that he had cut it off.
Okay, and who notified you of that?
Mr. Johnny Pelt.
And how did Mr. Pelt notify professional bail bonding of that?
He sent me a text message. Normally, that's the first protocol. He normally contacts me directly. And what he does is he contacts the client to find out what's going on.
Okay, do you still have this text message?
Yes, sir, I do.
Can you read the text message to the court?
Yes, sir, I sure can. Give me 1 second.
And just to confirm, this text message is on your phone?
Yes, sir, it is on my personal cell phone.
And how do you know it came from Johnny Pelt?
Because I have him as a contact. We deal with him daily.
Thank you.
The text message reads, Christopher Stabler just cut his monitor off, called me right after I got an alert, said it was getting hot. I find that hard to believe. Said it was going back on his, said it was not going back on his ankle, and I could talk to his attorney if I needed anything else. We'll send you and court's info in the morning, just a heads up of what's going on.
Okay, and what time did you receive that text message?
That was at 11:02 last night.
Thank you. No further questions.
Okay. Thanks, Ms. Rittenhour. Now, the court is going to take judicial notice of the standard bond conditions in County Court at Law Number 2 in cause numbers 330, 372, and cause number 330568. Based on the testimony that has come before the court in this particular case, Mr. Stabler's bond will be forfeited in both cases, cause number 330372 and cause number 330568. And the reason is he's violated the condition of his bond. Condition number 5 that states the defendant shall wear a global positioning monitor system device at the defendant's expense with written verification being submitted to the court within 3 days. And that was signed on October 12th of 2021. Judge Terrence L. Holmes presiding. Today's date is February 23rd of 2022. And that is the order of the court. Thanks a lot, Ms. Rittenhour.
Thank you all.
You're excused and you have a blessed day.
Thank you. You too.
You're welcome. Get that other one. That note, that paperwork. We forfeiting the bond. We're revoking it.
You have to do a motion to revoke.
Yeah, we're gonna have to just
The
do,
DA has to do that.
well, I mean, it's gonna be an order to revoke.
Or you want to increase the, put them at large without
Right.
proper bond and increase the
Right.
bond? Okay, that's fine. I can do, and what do you want to do with it?
His bond? He look like that's, I mean, put him at 50,000 each.
Yes, two cases?
Yes,
What's the other number? I have three.
it's on the top of the bond. You have the bond in your hand. The last couple of pages, it's,
Other bond conditions.
yeah, they're at the top.
50,000.
Yeah, see the two numbers at the
Yes,
top?
but I only see one on here.
Oh, yeah, don't worry about that. It's just bond, yeah.
Yeah, Ms. Stabler has been notified.
Who?
Ms. Stabler.
Okay, thanks. Now, we got Harmon.
Yes, sir.
Yeah, they gotta get him in state. They gotta get him in state. Harmon. Oh, here we go. Here we go. Okay, court is back in session in cause number 330-952, case of style of state of Texas versus Thomas Brian Harmon. Mr. Harmon, is that your full name?
Yes, sir.
Mr. Harmon, would you please raise your right hand? Mr. Harmon, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Harmon, you may put your hand down. Now, Mr. Harmon, previously the court advised you that your attorney of record is Mr. James Macon. However, Mr. Macon is not here, and standing in for Mr. Macon is attorney Joel Vasquez. And you informed the court that Mr. Vasquez have your permission to stand in for Mr. Macon. Is that correct?
Yes, sir.
Now, Mr. Harmon, I have before me a document that is titled Information, which was filed by the district attorney's office. This information alleges that on or about September 23rd of 2021, while you're in Jefferson County, Texas, that you committed, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Harmon, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Harmon, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleaded no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Harmon, I have before me a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Mr. Harmon, do you recognize this document?
Yes, I do.
On page 2 of the same document, Mr. Harmon, there are a set of initials on a line next to a box that's checked no contingent, which means no contest.
Yes, sir.
These initials are TBH. Mr. Harmon, did you place your initials on this document?
Yes, sir, I did.
On page 3 of the same document, Mr. Harmon, there's a signature above the line that is titled Defendant. Mr. Harmon, is that your signature?
Yes, sir.
And on the next document, Mr. Harmon, the next document is titled Trial Court Certification of Defendant's Right of Appeal. Mr. Harmon, do you recognize this document?
Yes, sir, I do.
And is that your signature above the line that's titled Defendant?
Yes, sir, it is.
There are 2 boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Mr. Harmon, I also have another document before me. This document is titled Discovery Certification. Do you recognize this document?
Yes, I do.
And is this your signature on the line that is titled Defendant?
Yes, sir.
Now, Mr. Harmon, prior to signing and initialing these documents that I've just mentioned to you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
To the best of my knowledge, yes, sir.
And Mr. Harmon, are you a U.S. citizen?
Yes, sir.
State. I have before me States Exhibits 1 and 2. State, you like to offer States Exhibits 1 and 2?
Yes, Your Honor.
Any objections?
No objection.
No objections. States Exhibits 1 and 2 are admitted. Mr. Vasquez, you've advised in counsel, Mr. Harmon, is there any evidence that he's currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Harmon, your attorney, Mr. Vasquez, has advised in counsel to you. Are you satisfied with his representation?
Yes, sir.
And has he provided full, effective, competent legal representation?
Yes, sir.
Mr. Harmon, your attorney of record, Mr. James Macon, has also advised in counsel to you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Harmon, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers are freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
Your Honor, the agreement is for 90 days in jail, probated over a term of 1 year. A $600 fine, 60 hours of community service, that Mr. Harmon participate in and complete the standard DWI classes during the term of his probation, alcohol assessments, and interlock device.
Mr. Harmon, state is offering that you serve 90 days in Jefferson County Jail. However, you would not have to serve any time in the Jefferson County Jail because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $600 plus court costs of $422, which comes to a total of fine and court costs of $1,022. You will be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You will also be required to pay a Jefferson County DWI education class an initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $170 a month. Mr. Harmon, will you be able to pay the $170 each month?
Yes, sir.
You'll also be required to perform 60 hours of community service, attend and complete. You're gonna attend and complete DWI education class, have an alcohol assessment, install a DWI interlock device on any vehicle that you own or operate, and you would also be required to adhere to the other standard terms and conditions of probation. Mr. Harmon, do you understand what the state is offering?
Yes, sir, I do.
And do you think that the state's offer in your case is fair and just?
Yes, sir, I do.
And do you accept the state's offer?
Yes, sir, I do.
Mr. Harmon, follow the plea bargain agreement that you have entered into with the state. Mr. Harmon, please stand on the X next to your attorney
Yes, sir.
and follow the directions of our court clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day.
You too, also.
Thank you. Okay, court is in session and calls number 329270. Case is style of State of Texas versus Reagan Christina Jones. Ms. Jones, is that your full name?
Yes, sir.
Ms. Jones, would you please raise your right hand? Ms. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, Ms. Jones, you may put your hand down. How are you doing, Ms. Jones?
I'm fine, how are you?
I'm doing fine, thanks for asking. Ms. Jones, you're here represented by your attorney, Attorney Don Boudreaux. Attorney Boudreaux, how are you doing?
Just fine.
That's good. Ms. Jones, I have before me an information that was filed by the Jefferson County District Attorney's Office. This information alleges that on or about May 26th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of theft. Ms. Jones, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Jones, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you're pleading no contest freely and voluntarily? Freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Jones, I have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Ms. Jones, do you recognize this document?
Yes, sir.
On page 2 of the same document, Ms. Jones, there are a set of initials on a line next to a box that's checked Nola Contendere. Ms. Jones, did you place your initials on this document?
Yes, sir.
On page 3 of the same document, Ms. Jones, there's a signature above the line that is titled Defendant. Ms. Jones, is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification of Defendant's Right of Appeal, Ms. Jones, do you recognize this document?
Yes, sir.
Is that your signature on the line above the line that's titled Defendant?
Yes, sir.
There are two boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal. Do you understand that?
Yes, sir.
Ms. Jones, I also have another document before me. This document is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature above the line that's titled Defendant?
Yes, sir.
Ms. Jones, prior to signing and initialing these documents that I've just mentioned to you, did your attorney, Mr. Boudreaux, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Ms. Jones, are you a U.S. citizen?
Yes, sir. Yes, sir.
State, I have before me States Exhibits Number 1 and States Exhibit Number 2. State, you like to offer States 1 and 2?
Yes, Your Honor.
Any objections?
No, sir.
No objections. States Exhibits 1 and 2 are admitted. Mr. Boudreaux, you've advised and counsel Ms. Jones, is there any evidence that she is currently mentally incompetent to stand trial?
No, sir.
Ms. Jones, your attorney, Mr. Boudreaux, has advised and counseled you. Are you satisfied with his representation?
Sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Jones, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers are freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
Your Honor, the agreement is for 1 year of deferred probation
Okay,
with 50 hours of community service. Ms. Jones will be required during the term of probation to attend and complete a theft class.
okay,
And Ms. Jones will be required during the term of her probation to pay restitution to Burger King in the amount of $1,223.
okay. Ms. Jones, the state is offering that you serve 1 year of deferred adjudicated probation. During the 1 year probationary period, you will not be required to pay a fine. However, you will be required to pay court costs of $352. You will also be required to pay restitution of $1,223 to Burger King. You'll be required to pay a probation fee of $60 each month, or your analysis fee of $15 each month, and court-appointed attorney's fees of $250. Now, Ms. Jones, your total monthly installments, that is the total amount that you will be required to pay each month for this probation, is $245. Ms. Jones, will you be able to pay the $245 each month?
Yes, sir.
You'll also be required to perform 50 hours of community service, attend and complete a theft class, pay restitution in the amount of $1,223 to Burger King. And as I said earlier, the fine will be waived. You will also be required to adhere to the other standard terms and condition of this probation. Ms. Jones, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer? Ms. Jones, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Jones, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney, Mr. Boudreaux, about the non-disclosure. He's quite competent in those matters. Ms. Jones, please stand on the X next to your attorney and follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you.
And Mr. Boudreaux, I think this is your only case. Once you finish signing the once you finish signing the paperwork, you'll be free to go as well, and you have a blessed day.
Thank you, sir.
Mr. Wilkerson. Let's see, we got, we'll do, we have.
See you tomorrow.
Ms. Cook, court is in session and cause number 330884. Case is styled State of Texas versus Victoria Lane Cook. We have Ms. Cook, present in court. Ms. Cook, is that your full
Yes,
name?
Yes, sir.
Ms. Cook, would you please raise your right hand? Ms. Cook, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Ms. Cook, you may put your hand down. How are you doing, Ms. Cook?
I'm doing pretty good. How about you, sir?
I'm doing fine. Thanks for asking, Ms. Cook. You're here represented by your attorney, Attorney William Wilkerson. Attorney Wilkerson, how are you doing?
I'm doing well.
That's good. Ms. Cook, I have before me a document that is titled information. This document was filed by the District Attorney's Office of Jefferson County. This document alleges that on or about August 27 of 2021, while you were in Jefferson County, Texas, operating a motor vehicle, that you committed to class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Ms. Cook, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Cook, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Cook, I have before me a document that is titled misdemeanor plea admonishment. It is also labeled as State's Exhibit Number 1. Ms. Cook, do you recognize this document?
Yes, sir.
On page 2 of the same document, Ms. Cook, there's a set of initials, VK.
Yes, sir.
Ms. Cook, do you place your initials on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
On the next document, which is titled Trial Court Certification to Defendant's Right of Appeal, there's also a signature above the line that is titled Defendant. Is that your signature?
Yes, sir.
There are two boxes that are checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
Ms. Cook, I also have another document before me. This document is titled Discovery Certification. Do you recognize this
Yes,
document?
sir.
Is this your signature on the line that is titled Defendant?
Yes, sir.
Ms. Cook, prior to signing and initialing all of these documents that I just mentioned to you, did your attorney, Mr. Wilkerson, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir. To the best of my knowledge.
State, and Ms. Cook, are you a U.S. citizen?
Yes, sir.
Okay, state, I have before me states exhibits number 1 and 2. State, you like to offer states 1 and 2?
Yes, Your Honor.
Any objections?
No objection.
No objection. States exhibits number 1 and 2 are admitted. Ms. Cook, your attorney, Mr. Wilkerson, has advised and counseled you. Are you satisfied with his representation?
Yes, sir. I am.
has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Wilkerson, you've advised and counsel Ms. Cook. Is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Okay, Ms. Cook, I will accept your plea of no contest. Oh, let me back up. State, I have before me states exhibits 1 and 2. State, you like to offer states 1 and 2?
Yes, Your Honor.
Any objections?
No, Your Honor.
Okay, no objections, states 1 and 2 are admitted. Ms. Cook, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your pleas and waivers are freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, the agreement is for 180 days in jail, probated over a term of 1 year, a $1,500 fine, 80 hours of community service. Ms. Cook should attend and complete standard DWI classes, drug and alcohol assessments, and an interlock device.
In the law.
And just for the court's understanding, she does not have a vehicle, so she'll need a home or.
Yeah, you talk to the DA's office, I mean, not the DA's, the probation office.
Probation, I'm sorry.
They'll, okay, let me do this. Did I make the change on this? No, I didn't make the change. Hmm? Cook is a DWI. You talking about? Okay. Let me do this. And now, Ms. Cook. Okay, Ms. Cook, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail in this case because you will be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $1,500 plus court costs of $422, which comes to a total of fine and court costs of $1,922. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to reimburse Jefferson County the court-appointed attorney's fees of $250. You'll be required to pay Jefferson County DWI education class and initial evaluation fee of $125. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month, is $275. Ms. Cook, will you be able to pay the $275?
Yes, sir.
You will also be required to perform 80 hours of community service, attend and complete DWI education class, and have a drug and alcohol assessment. You'll be required to install a DWI interlock device on any vehicle that you own or operate. And you will also be required to adhere to the other standard terms and conditions of your probation. Ms. Cook, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay. Ms. Cook, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Cook, please stand on the X next to your attorney. Follow the directions of our clerk. Once you finish following her directions, you'll be free to go and you have a blessed day.
Thank you very much.
Thank you. Clause number 331120, case is style of State of Texas versus Constance Duval or Constance Nicole Duval. Your name is Constance Duval?
Yes, sir.
Ms. Duval, would you please raise your right hand? Ms. Duval, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Ms. Duval, you may put your hand down. How are you doing, Ms. Duval?
I'm doing good. How are you?
I'm doing fine. Thanks for asking. Ms. Duval, you're here represented by your attorney, Mr. William Wilkerson. Mr. Wilkerson, I have a motion before me, a motion to forfeit that was signed by Ms. Duval and Assistant District Attorney, Mr. Ham. Mr. Ham, is that correct?
Yes, Your Honor, that is correct.
Now, Ms. Duval, I have before me a document that is titled Motion to Forfeit. You recognize this document?
Yes, sir.
Is this your signature on the line that says Defendant?
Yes, sir.
Prior to signing this document, did your attorney go over this document with you?
Yes, sir.
And did you read and understand everything in this document?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Ms. Duval, I will grant the state's motion to forfeit the weapon, in this case, to the Beaumont Police Department. Now, state, do you have another motion?
Yes, Your Honor, the state would move to dismiss this case pursuant to our agreement.
Okay, that motion will be granted. Ms. Duval, I'll be signing the motion to dismiss in a few seconds, and you'll be able to get a copy of this motion from your attorney as soon as I sign it. So just have a seat. You can have a seat in that chair with the black and yellow tape on it.
Yes, sir.
And I'm signing the dismissal as we speak.
Your Honor, that concludes my cases for the day. May we excuse?
Yes,
Thank
we're gonna give you a copy of the dismissal.
Yes.
You may be excused.
Thank you.
Duval.
Correct. Thank you very much. You're welcome. Thank you.
Okay, so the dismissal is printing off right now. Oh, here we go. Mr. Samuel, are you here on your jail in January, cause number 327-408? And cause number-
Yes, Your Honor.
Okay, is that Mr. January right there? Okay, Mr. January, would you please come forward? Okay, court is in session in cause number 327-408 and cause number 330-956. And the case is styled the state of Texas versus Jalen Jamal January. Mr. January, is that your full name?
Yes, sir.
How are you doing, Mr. January?
Doing okay.
You doing okay? That's good. Mr. January, you're represented by your attorney, Mr. Alwyn Samuel, who is appearing via Zoom. Mr. Samuel, how are you doing?
I'm great, Your Honor.
That's good. Mr. Samuel, what is your announcement in Mr. January's cases?
Yes, Your Honor. Mr. January he had some trouble with his vehicle this morning. I was in court earlier. However, we have discovery, but I've not had opportunity to review this discovery with Mr. January. This is
Okay.
our first appearance, and I'm asking that the court allow us an opportunity to visit about his case prior to making an announcement.
Give us all. Okay, this case will be reset to April 13 of 2022. Mr. Samuel, your reset will be sent to you. This will conclude your cases. You're free to go. And you have a blessed day. And thanks for being patient with us. And Mr. January, you're gonna get your reset from our court coordinator. Gonna stand on the 4X. Once you get your reset, you'll be free to go. And you have a blessed day as well.
You too, sir. Thank you.
You're welcome. Okay, Miss Morrison.
Yeah.
We have cause number 330006, case is styled the state of Texas versus Joshua Clarence Mouton. Mr. Mouton, would you please come forward? You need a seat, Ms. Morrison? You all right? All right.
Thank you so much.
You are. Now, Miss Mouton, your full name is Joshua Clarence Mouton?
Yes, sir.
Okay, this is cause number 330-006. Mr. Mouton, you're here represented by Attorney Stella Morrison. Attorney Morrison, how are you doing?
I'm doing pretty good.
I said Attorney Morrison.
I'm sorry.
How you doing, Ms. Morrison? I'm doing fine. And how are you doing, Mr. Mouton?
Doing pretty good.
That's good. Now, Ms. Morrison, what is your announcement in Mr. Mouton's case?
We would like to get this case dismissed today. The recommendation is 90 over a year, plus $800 fine, plus $60 for community service. I think Mr. Mouton's record will reveal that he has no prior criminal history.
Okay.
All right, considering that to be a fact, Your Honor, and considering what he charged with, but why he was charged with it, I ask that the court make a judgment call in this case. In that, the Mr. Mouton is charged with prostitution, and I think he was attempting to be retaliatory against his fiance because his fiance had an outside relationship going on, and he learned about it. And that was his way of getting back at her, and he told her. But he didn't know how to consummate or materialize the incident without being caught. That tells you how much of a criminal he is. Nonetheless, he was charged with prostitution and no prior criminal history. And I think the person who he was attempting to consummate this act with, probably a police officer, Your Honor. He doesn't even know how to pick him. Considering that to be the case, Your Honor, we would act that the court change the recommendation of the ADA and sentence this man to 2 days in the county jail and give him credit for 2 days.
So let me ask you this. Are you doing an unagreed plea? Or what are you doing?
This is unagreed.
Okay, because you said, you started off by saying that you wanted a dismissal, and then you said you wanted,
Well, I'm asking, unagreed, part of my unagreed is to ask for dismissal.
yeah, you mean, you have any authority to support your position, any case law, any statutes?
No,
Okay,
I asked the court take into consideration his reason.
yeah, well, that oral motion would be denied. Now, if he wants the court to do an unagreed plea, this is what the court normally does. Okay, he would have to fill out paperwork, and then I normally get a PSI report.
You do all of that in misdemeanor court?
Yes,
I mean, no, you're making sure your track record is clean, huh? Can't nobody get you.
I tried to get all the information I can before I make a decision.
I appreciate that.
Yeah,
I truly appreciate that.
yeah,
You're different, you're a unique breed.
okay. So what we can do is I can reset this case because, and the reason why I want to reset it is because the misdemeanor side is not set up like the felony side. You know how the felony side,
Yes, sir.
you can do your paperwork today and then come back for your PSI Thursday.
Exactly.
They don't save the paperwork on the misdemeanor side, so you would have to do the paperwork all over. And so what I can do is reset the case for a plea, but in the meantime, we can have the probation department to do a PSI. And so when we come back on the day of the plea, we'll already have a PSI.
Do I have a right to respond to that?
Yes,
Okay.
yeah, oh, yeah.
No
Both
problem.
sides
I
have,
just want to make sure I have a right. to
oh, yeah,
respond.
both sides will get a copy and then you'll argue
Okay,
on both sides. Okay, so let me do this.
let's do that.
Let's give him about 45 days, because it may take a while. So we're gonna just reset the plea, but we're gonna do PSI.
Okay.
And so we'll contact, he'll have to
Love
go
that.
to the probation office. Then they're gonna set him a time to come back in to do
You
the
sold that
PSI.
to Woods next door?
Huh?
We need to sell that to Woods.
Oh,
We need to do that. Because that is the problem. The judgment caller You don't have a clue about the person standing before him other than his call number. That is the problem.
Okay. Okay, so what we're gonna do, we're gonna reset this case, and Ms. Morrison, you're gonna get your reset. Once you get your reset, you'll be free to go. And you have a blessed day, and once you get your reset, from your, attorney, you'll be free to go as well. Now, Ms. Morrison, you had another case.
Yeah, that person is at Methodist Hospital as we sit and speak, as we stand. and
David
speak.
Lewis?
His wife is having heart surgery.
Okay, that's
So
three.
I told him, I
three-
think you would excuse him on that.
Well, what we can do is, I mean,
I told him to bring back something from the doctor to prove that
Yeah.
she has heart
now, do
surgery.
you,
today.
well, I don't know, well, you were aware that even if he didn't appear in person, he could appear by Zoom or by telephone.
He could have called you.
Yes, that's what I'm telling you.
Give me a number to call you, because he did ask me. I told him I didn't know your number
Yeah,
like that. I
You
have
could
his
get
cell
that
number.
from the court coordinator when she comes back in.
Okay. 'Cause,
Okay.
He asked me that,
Okay, so you could just have a seat.
so I'll
Well,
have him call you.
All right, yeah, he'll call the court. All right. Yeah, we get it done before 4 today. That's
Before 4,
yes.
thank you.
Is it April 20th? You think that's enough?
I think so. Or we can do,
I'll have him call. Get in touch with him.
May 4th, yeah, May 4th. Okay, yeah, he's gonna call. You'll get the number from the court coordinator.
Okay, and because I don't know, how long that surgery's gonna last.
Right.
He's at Methodist Hospital, I know that much.
Okay. All right, Mr. Sir, you can stand over there, and Mr. Mouton, is that correct? You get your reset from your attorney. Once you get your reset from your attorney, you'll be free to go and you have a blessed day. Let's go back on the record. Okay, we're gonna go back on the record.
No, I work at Home Depot.
Okay, well. He can tell me himself, but
Yes, sir.
I think
that's Mouton.
I sent these.
We're gonna go back on the record on this.
Huh? And then I think I messed up these two. I think I sent those, and I don't know what happened with these. This one, these two, was actually. Hmm? You see a new ball? The only one?
Court is back in session in cause number 330-006. The case is out of the state of Texas versus Joshua Clarence Mouton. We have Mr. Mouton backing up before the bench. Now, while the court was, I guess, in recess and did not have the had the mic on mute, Mr. Joshua Mouton made a statement to the court. And Mr. Mouton, what was your statement?
That Mr. Day said,
Okay, you said that Mr. Leday said hi. Now, Mr.
Mr.
Leday, now, Mr. Leday was a gentleman who had worked on my campaign, and Mr. Leday actually was the guy who put out signs. Now, prior to, did Mr. Leday suggest to you to tell me hi because you thought that you maybe get a favor or something from the court?
no, sir.
Okay. Now, have the court, prior to this day, have the court talked to you or discussed with you anything about your case?
No, sir.
Have Mr. Leday stated that he had approached the judge, which is myself, regarding your case?
No, sir.
Okay. So, in the purpose of you passing the message from Mr. Leday, what was the purpose of that?
He just told me. I didn't know, he just told me.
Okay. Now, State, do you think that there's anything within the statement that Mr. Mouton made that would require the court to recuse itself because there may be appearance of impropriety?
Absolutely not, Your Honor.
Okay, Ms.
You know,
Marcy?
I know you think Jim Crow still exists and it does, but I don't have any problems with you running the judge. The problem I have is you saying God bless you after you talk it to him, to be honest with you.
Okay.
All right.
All right. So, so this case is going to be reset?
Yes,
Okay. And you've already got your reset date?
yes.
Okay. Well,
Maybe be excused.
you may be excused and you and your client have a blessed day.
You too. There you go.